Hello, I'm Alison Colley from Real Employment Law Advice, and this is a recording of a presentation that we have delivered to our HR Harbour clients here at Real Employment Law Advice, which I thought you might find useful. It's aimed at businesses, but it's obviously available for anyone to watch, and hopefully you'll find it helpful in giving you an update on what's happening in relation to the furlough scheme and the COVID-19 situation that's going on in the UK. So what are we covering today? So it's going to be a short run through giving you an update on the furlough scheme that was announced on Wednesday the 12th of May by the Chancellor. And what does it mean? A little bit about the COVID-19 secure requirements for employers, how to deal with employees who are reluctant to return to work, what you can do in relation to employees with childcare issues, a little bit about annual leave considerations, and finally planning ahead, some steps employers need to be taking in relation to planning for the future. So yesterday, I'm recording this on Wednesday the 13th of May, and so this took place on Tuesday the 12th of May. It was announced within the Commons that the furlough scheme or job retention scheme would be extended for a further period. The Chancellor announced that the job retention scheme would continue as it is in its current state and availability until July 2020, so until the end of July 2020. Thereafter, from the 1st of August to the 31st of October, the furlough scheme will continue with changes, and those changes will enable employers to bring staff back part-time. Employers will have to contribute to the wages or the costs, and more detail will be announced by the end of May. Now, more detail is to come, but we speculate here that employers will have to top up to 80% from a lower percentage contribution from the government from the 1st of August. And this may be if you bring employees back part-time, or it may just be generally. So in my view, I think it's likely that the employers will have to start contributing something towards the 80% minimum pay that employees will receive, whether or not they're working. Again, as I say, more detail to follow, but that's just our view on it as it stands. So employers need to start preparing for the 1st of August, and obviously we'll have more detail shortly. The second thing we're going to cover is the COVID-19 Secure in 2020, which is the government guidance that has been published in relation to helping employers get employees back to work. So it's working safely guidance, which you can find here on the .gov.uk website. There are 8 guides currently, and they cover various industries as listed there. The key points to note from the guidance is that it is guidance only. It's not statutory guidance, so it's not legally binding. And normal health and safety laws apply in relation to employers' obligations to employees. You should expect it to be updated. It does say that they will update the guidance. So it is important when you're having a look at the document to check the relevant date that it was published, because they're not always quick to update it or to make it clear, should I say, when it's been updated. So if you have a copy of the guidance, so I've got the office one here. You have a look, it says the 11th of May on it, and inside, on the inside cover, it says this version is up to date as of the 11th of May 2020. So just make sure that you're looking at the most up-to-date guidance when you do it. It does include practical considerations of how to apply the guidance to your workplace, and the whole idea is to assist businesses in getting back to work. However, it does make it clear, as has been published by the government, that where possible, employees should remain working from home. So there shouldn't be this big rush back to the office if people can continue to work at home. One of the things that has been asked and is often quoted by employees is about PPE, and is it required? And within the guidance, as I've highlighted here, a couple of key parts. It does say that it's a different type of risks to the risks you normally face in a workplace, and it needs to be managed through social distancing, hygiene, and fixed teams or partnering, not through the use of PPE. And then it goes on to say, unless you're in a situation where the risk of COVID-19 transmission is very high, your risk assessment should reflect the fact that the role of PPE in providing additional protection is extremely limited. However, if your risk assessment does show that PPE is required, then you must provide this free of charge to workers who need it, and it must be provided to fit properly. Now, so in most cases, it's unlikely, therefore, that you will need to provide gloves and masks, as many people have started to do, unless your risk assessment reflects that it will provide additional protection. And much of what has been published suggests that the kinds of face masks that people are using don't actually protect them from getting the virus, but rather it can help to limit them spreading the virus. So I've said here, it may give employees reassurance upon return. So whilst your risk assessment might highlight that actually social distancing and hygiene is sufficient and having a mask won't make any difference, if it gives employees reassurance upon their return, you should give consideration to providing it anyway. Or at least making it available. You don't have to make it compulsory, but you could say we have provided masks if you wish to use them. So some action steps that employers need to take in relation to the guidance that's been produced. The first thing is you definitely need to undertake a COVID-19 risk assessment. So have a look at what the risks are within your own business. Consult and discuss with staff, health and safety reps and or union representatives about what steps you're going to make. Now, I've put this here at number 2 because I think it's really important for employers to actively engage and listen to staff about their concerns on returning to work. I think it's much easier to get buy-in from employees, and you're less likely to seek resistance from staff if you have gone out to them in advance and said, here's the guidance from the government, so I'd suggest sending a copy electronically. You don't have to send a hard copy, and along with your initial risk assessment, and so these are the steps that we're proposing. What do you think? What would make you feel happy to return to work? How would you feel safe? And ask them for their ideas and consult with them. You're much likely to get them to come along with you and to be flexible and to be involved if you've asked them for their opinions. Identify sensible measures to control the risk that are relevant to your organisation. It doesn't have to be costly. You don't have to put screens up everywhere. You don't have to think about, huge changes to your office environment if they're not going to be sufficient to control the risk anyway, or if there are more simple steps that you could take. I've said there, share the results of the risk assessment. So the final results of the risk assessment should be shown to employees. You must display the compliance document, which I'll show you on the next slide, and order PPE if you need to, and make the necessary changes to the workplace. So plan ahead, take that action now. On the same web page as you'll find the guides I've referred to, you will also find a downloadable document, which is this compliance document, which you're required to complete and to display within your organisation. So as you'll see there, it says we've carried out a COVID-19 risk assessment and shared the results with the people who work here. We have cleaning, hand washing and hygiene procedures in place. We've taken all reasonable steps to help people work from home. We've taken all reasonable steps to maintain a 2-metre distance. And where people cannot be 2 metres apart, we've done everything to manage transmission risk. So those are the things that as an employer you're required to sign to say that you have done the 5 steps to safer working together. So some practical steps I've highlighted here, obviously, is increasing the frequency of cleaning and highlighting the particular areas that you've identified as being risky within your business, hand washing notices, and obviously notifying your staff about the requirement to hand wash. I know that many employers were already starting to do this before we went into lockdown, so it's just ensuring that you're reinstating those and highlighting those. Taking temperatures of staff. Now, I know that a few organisations are doing this. I'm not sure of the effectiveness of it, but if you do intend to implement this as one of the measures as part of your risk assessment, then I would recommend that you do consult with staff on this and that you take necessary steps to make sure people feel confident in the process, that the right people are doing the temperature checks and that staff are happy to do that. Consider screens or barriers, particularly if you work in a customer-facing environment. Reduce the time where possibly exposed to others. So again, it's about ensuring that people, if they are having to be around other people, if you can't socially distance within the workplace, that the risk is managed by reducing that time. Consider fixed teams or partnering to reduce possible contacts. Again, I like the idea of this because it kind of creates that bubble, if you like, of employees within the workplace, so that the risk of infection or spreading further than that team is maintained and contained. And then again, consider adjusting working times on a temporary basis whilst you're managing these risks. So there's some practical steps to take. The next thing I'm going to cover is the reluctant returner. Now, as well as providing advice to employers, we do provide advice to employees on a regular basis, and we're starting to see more and more people contacting us who are reluctant to return to work. There are people who are asking if they can stay on furlough, if they really have to return, and we've even been contacted by an employer recently. An employer contacted us and asked for advice after calling ACAS, and interestingly they were informed by ACAS that they could follow the normal procedure as though COVID-19 were not in play. So that would be, if you had someone who refused to work, going through a disciplinary process and which they did instigate. Now, I'm not suggesting that you do take this route. I think that we're not in the same situation as we would be without COVID-19. And I think you should take that into consideration in the action you take. Of course, from a legal perspective, if an employee's return, and from an employment law perspective, if an employee refuses to return to work, then of course you can go down the route of disciplinary. But I'm suggesting you consider other things first. So the first thing is, of course, handling them with care. We're in a situation where people's views on the virus vary wildly. So you have those people who are extremely anxious and extremely worried about catching the virus and are taking all steps to mitigate any risk to them or their family. And then you have those others who are less worried, who are a bit more blasé about it and are happy to return. So you've got a real wide spectrum of people, concerns, stresses, worries about it. So don't just go into it, I think, like a bull in a china shop and go down the disciplinary route to start with. Handle people with care. Remember, they're human beings. Communicate with them and seek to reassure them about what's happening, what you're doing, what steps you're taking. And hopefully, if you've taken my advice and you've consulted with them in advance and started going through that process of the risk assessment with them, you'll have less likely to have people who go down this route of not wanting to return. Of course, consider if they are in the high risk group. If they're one of those people who are shielding or are high risk for some other reason, then you need to talk to them about that. Where possible, try to reach a compromise, a way in which they're going to feel safe to return, or what you can do. Of course, a disciplinary process is available for you if you want to, but my advice is not to consider that, or at least consider it as a very last option. Ultimately, if they still don't want to return to work after you've been through those steps, you can offer them unpaid leave, or you can offer them to take some of their annual leave. But the main thing about this to note is employees don't realise that once you've asked them to return to work, there's no obligation for you to continue to pay them furlough pay. And if you want them to return and they refuse, you don't have to put them back onto the furlough scheme. So you could tell them, actually, look, if you don't return, it's going to be unpaid leave because we've got work for you. And if you're really concerned about the virus and you're not willing to work at this stage, it could be that you're not willing to return to work until there's a vaccine, which could be some time. And so therefore ensuring that the employee understands that this isn't something that's going to go away quickly. And so it's better to try to communicate and reach a resolution that they're happy with. And of course, seek advice if you can't reach an agreement. You know, if you're having issues with an employee, then we recommend that you seek some advice about that specific issue. The next up is childcare issues. Now, I thought this, when I was preparing this presentation before the announcement from the Chancellor, I thought this was going to be a bigger issue because potentially children are not going to be returning to school for some time, childcare settings aren't going to be open, and other family members aren't going to be available to help looking after them. So it was likely to be a bigger issue if the furlough scheme was taken away. But helpfully, you can continue to furlough employees if they have childcare issues. Now, what I've said here is you need to be very careful about your process and what you're doing and be mindful of equality issues. So don't just assume that because somebody has small children at home that they are going to want to remain on furlough if you're bringing their colleagues back. So do discuss with them, see what they want to do, consider alternatives, look at flexible working, but also be mindful of the fact that they may be under stress and pressure with having children at home as well. So the real takeaway there is to say, yes, you can continue to keep employees on furlough who have childcare issues until the end of the furlough scheme if you need to, but also be mindful of any equality issues. I'm just going to touch upon holidays here because this is an issue that has been coming up fairly regularly, and it's one that's currently undecided. There's no firm outcome or legal assurance, I suppose, I can give you in relation to the issue around holidays. So the first thing to note is that an employee can take holiday and be furloughed at the same time. So if an employee decides they want to take holiday during the furlough period, or they have holiday booked and they want to take it, then they can continue to do so. However, you must pay them 100% of their pay for any holiday time. The legal position on requiring an employee to take holiday is undecided. So whether or not you can stipulate that an employee must take some of their holiday during the furlough period is one in which there are currently two conflicting legal opinions on. So ordinarily, you would be able to give notice to your employees to require them to take holiday at a particular time. So for example, if you were having a shutdown or over Christmas, often employers will keep it in their contract and say you must take holiday between X and Y every year, or if it's not in the contract, then an employer can give double the notice of the time that the employee is required to take. So sometimes you might have an employee who is reluctant to take annual leave and an employer might want them to take some time off. So they could say, you know, you're required to take 5 days. I'm giving you 10 days notice that you have to take that. Now, the reason why the legal opinion on it is divided is because some solicitors and barristers are of the view that the furlough period would be viewed in much the same way as sick leave would. And of course, you can't require an employee to take holiday during any period of sick leave. Now, my view differs to that, and I think that, and particularly given how long the furlough scheme is going to be running for, it is going to be low risk for an employer to require employees to take accrued holiday during the furlough period. That comes with the caveats, because until there is a case decided by the tribunals and the higher courts, it's difficult to say for sure. But I think if you behave reasonably, you don't require your employees to take all of their annual leave during the furlough period, thereby leaving them with no leave when they return to work, then I think you will have a low risk of running into difficulty here. Again, you need to be sure that you're communicating with staff about this, you're behaving fairly and giving consideration to the wider implications of doing so. So if you're concerned that employees are continuing to accrue leave that they're not going to be able to use, you could stipulate that they have to take, a couple of days here, a couple of days there, and which you'll pay them 100% during the furlough time. But also, of course, noting that the law was changed temporarily so that employees can carry forward accrued for the holiday up to 2 years if they're unable to take it due to the COVID-19 situation. So employees can carry forward if you don't want to stipulate that they use it now, and they still have some left after they return. If you have any particular questions about annual leave, or you have a specific scenario, then we do recommend that you get advice on that. There are lots more things to consider other than the legal risks, including, as I say, being fair to staff and making sure that people aren't burnt out in the long run. Now, finally, I just want to make a few notes for you about planning and planning for the future. There are a number of things I think you should be considering now in terms of return to work. So I've suggested here that you start modelling various scenarios about return. Think about what resources you will need and what can you afford. And what is cash flow going to look like? So helpfully, the furlough scheme is being extended. It's not just coming to a complete end, as some people thought it would. There is going to be a period of time where you could bring people back part-time, so thereby building the business up slowly and obviously the liabilities. But really, how long is it going to take you from starting up operationally again to actually having the money to pay? What is cash flow going to look like? How agile are you? How agile are your staff? Are they willing to be flexible? Do your contracts allow for flexibility? What are you committed to? When are you likely to need employees to return? So thinking about timing. And then finally, will you need to make redundancies? There is a fine line here between looking at the resources you need, thinking about what's going to happen with a crystal ball in most cases, and then redundancies, because you don't want to be making redundancies and losing good quality staff, people you've trained who have the right skills and experience, if actually when you come back, you're going to be, just as busy as you were. So I know there's a lot here that we don't know, but really it's sort of modelling these things and various different scenarios will help you to reach the right conclusion. And communication comes as part of your planning. I recommend, if you haven't already, that you have regular and open communication with your staff during this time. Share your plans and thoughts on the future with them. Be open, consult and seek their views on things like risk assessments. Ask them for ideas and suggestions. Some of the best ideas come from the people that work for you. So make sure that you are engaging with them. People will feel better about you as their employer, about the whole situation and the return, if they feel that you're engaging with them and you're being honest and also, asking them for their opinion. And then start preparing them to return to work. For some people, they might have been off for several weeks, and whilst you may not have to give them notice, if you haven't agreed a minimum notice period, you don't have a minimum notice period to give them to return. It's really important to make sure that you start to prepare them so they understand what's going to be happening and they can gear themselves up, mentally and sort of psych themselves up to return to work and understand and plan. And that's where no surprises comes in. Make sure they understand what's happening. If you do need to think about redundancies and redundancy planning, you need to think about the minimum timescales here. So these numbers are the numbers of employees that you might be making redundant within a 90-day period. And then that gives you the days that you're required to consult. So if it's 19 or less within a 90-day period, then I've said a very minimum 2 weeks for consultation plus the notice period. if it's 20 to 99, there's 30 days before the first dismissal takes effect, and 100 plus is 45 days. So think about that in terms of your planning. We've got a bit more time now with the furlough scheme being available. So if you do think you're going to have to make cutbacks and you think, well, actually, I'm going to wait towards the end of the furlough scheme to be fair to staff to make sure that they have their income during that time, then keep these periods in mind. And then that brings everything to a conclusion. There's just a note here about some resources for you. If this is your first time experiencing real employment law advice, then you won't know about these resources here, sorry. So we have a fortnightly newsletter which we send out by email, which you can sign up on the website, which is realemploymentlawsadvice.co.uk, or by sending us an email with a note saying you'd like to be added to the mailing list. You can email me, it's alison@realemploymentlawsadvice.co.uk. We also have a number of articles and videos on our website, which are Real Employment Law Advice and advice for employers. We have articles on LinkedIn. There's a fortnightly podcast. If you search the Employment Law and HR podcast, you'll find that. We have a YouTube channel where perhaps you're watching this, and will find us on social media. If you have any questions about anything in this video, then you can leave them below in the comments section and we'll be happy to answer those, or you can email me or my colleague Albert. It's alison@realemploymentlawsadvice.co.uk, and we'll answer your questions about anything that we've covered. And of course, if you like the content, then please click the like button, and if you subscribe to our YouTube channel, then you'll get all of the updates as and when they come out. Thanks very much for watching this webinar, and I hope you have a great day.